Zandile Mafe, the man accused of starting the fire that gutted Parliament, now has terrorism charges added to his charge sheet. Well, let's get more on what we saw unfold in that courtroom. Advocate Romeo Nthambeleni joins us. Advocate Nthambeleni, good evening to you, and thank you so much for your time tonight. A surprising turn of events in that there have been quite a number of significant developments in this case that I suppose, the public weren't being kept abreast about, not least of which the psychiatric evaluation that the suspect has undergone during this period, according to the state that has classified him as having paranoid schizophrenia.
Okay, thank you, Kathy. Good evening to you and the viewers. Quite correct, Kathy, to say that the state has conducted some sort of mental evaluation in relation to the provisions of Section 77 to Section 79 of the Criminal Procedure Act. And we have seen that it was today said that it was an ambush, but the state made sure that they wanted to tick the boxes in relation to the kind of capacity of the accused person when he faces the charges, because that is the requirement under the provisions of the Criminal Procedures Act that we just referred to now.
How would such a process ordinarily be entered into? And the defense, of course, said it absolutely did not know that this process was taking place. Would they needed to have been informed?
Basically in terms of the proceedings, in terms of pre-trial proceedings, the legal representatives of the accused have to be aware of what the intention of the state is in relation to the constitutions and the requirements of the rights of an accused person. But I think, as you have rightfully pointed it out, Kathy, that the way in which this matter has unfolded, it appears that the state went ahead to actually procure this information without the knowledge of the legal representatives. I'm not quite aware as to when the legal representatives of the accused person came on record, and whether when they came on record, the state already commissioned the investigation to be done under the provisions of Section 77 to 79 of the Criminal Procedure Act.
What are the implications of this diagnosis for the future of this case?
The implications are quite important, Kathy, because if it is indeed found that the accused person faces the required necessary capacity, it means that the trial will not proceed, because the person, in terms of criminal law and its requirements, basic requirements, must have the criminal capacity to be able to face the case and answer the cases and have the correct required criminal capacity and the intent to have committed the crime. So the moment you remove that, you don't have a trial, and you have a situation where the person must be sent to a correctional facility or a facility where they will be under medical observation instead of an imprisonment.
So, Advocate Nthambeleni, on the one hand, the state then saying that they've come forward with this diagnosis, which effectively means that on some level they also have an appreciation for the state, the impact of this diagnosis on their case. On the other, the charge sheet is increasing. They've now added terrorism to the charges that the accused here is facing. Does it all make sense, or is it strange that that has happened?
Yeah, I think you're quite correct. With the knowledge of the diagnosis, the reasons of actually imposing a further charge really does not make sense, Kathy, because looking at what will happen, perhaps we are jumping the gun here. They are saying that they want to wait for the accused legal representative to conduct their own investigation, so that when there is two opinions that come to the very same agreement, then a proper determination has to be done. So if they fail to actually put another charge, they cannot be able to do it at a later stage. So I think maybe here they wanted to err on the side of caution to add the charge, because it also raises the schedule in terms of the Criminal Procedure Act, because terrorism falls within the Schedule 5 and 6 of the schedules in terms of the Criminal Procedure Act. So perhaps they wanted to err on the side of caution here.
So are you saying that effectively, despite the fact that they've come forward to court with this diagnosis, the state could very well be leaving the door open for different doctors to come to a different conclusion?
Yeah, absolutely. I think that evaluation is not conclusive up until the accused person and their legal representative, they commission their own investigation, and then we have the reports, and then from those reports, the courts still have to make a determination on the fitness of the accused to stand trial based on the evidence that is going to be produced before court. So you might find that when he's sent to the evaluation by his own medical representatives, you find that they're saying that he actually does not suffer that, or he's fit to stand trial. And then if you have not professed the correct charges, you have a problem because you cannot come and do it later.
Advocate Romeo Nthambeleni, let's leave it there for tonight. Thanks for your time.